In this episode, a first look at tendering, Canada's two-contract theory. Welcome to Two Architects and a Lawyer. Join architect Luis de Miguel in Valencia and architect lawyer William McLean in Vancouver for observations and commentary on all things design. Here are William and Luis.
Today, we're going to look at a case that changed how every person who's listening to this submits or receives a bid. I'm going to give you a scenario, and I don't want you to think like a professional. Just give me your gut reaction.
Sure. Will do.
Okay. All right, it's 1981, and a contractor named Ron Engineering is bidding on a massive water treatment project in Ontario, and their bid is $2.75 million. They've included a $150,000 deposit check with their bid. But when the tenders are opened publicly, they immediately see that their bid is about $600,000 lower than the next bidder. And as soon as they look at the paper, they realize they've forgotten to add in $750,000 in costs. So they call the owner and they say, look, we made a huge clerical error. Our bid's wrong. We'd like to withdraw our bid. We want our $150,000 deposit back. It was an honest mistake. You haven't actually told us you've accepted our bid, so let's just call it off. So gut reaction from you?
Well, yeah, gut reaction. I think the first thing is, do I know as the owner, as the eventual owner of this project, do I know these people well? Have I worked with them before? I think there's a whole human aspect to this thing beyond the law. There's some leeway here. Do you wanna force the guy into signing the contract? Can you do that?
There's a lot at risk here. First of all, it's a public tender, so this is important politically. It's public money, so everything has to be accounted for, but also the whole bidding system, which is an issue. Bidding is an extremely complicated procedure that not just involves these two parties, but the whole chain of contracts below the general contractor. His subcontractors, their subcontractors, their material suppliers, their workers, they've all contributed towards this process. They've got competitors breathing down their necks. The government has got to be concerned about what the public's view of all of this is. And there's a bigger issue at stake rather than just the honest or otherwise error by this particular contractor. Basic contract law says you have to have a meeting of minds before there's a contract formed. And prior to this case, the standard rule in tendering was that it was just like buying a house. An owner might say, the seller might say, my asking price is $1 million. Come to me with your offers. People bring them forward. The owner picks and chooses one of them. Once he's accepted an offer, a contract is formed. And that's what, until this case, tendering was all about. And in this case, the Supreme Court of Canada decided to completely change the rules, and they've been changed ever since. They said that for a bidding system to have commercial certainty, there have to be rigid rules. And if it was easy for a bidder to withdraw, then the owner could have no security. The competition would just quickly become informal negotiations. Anybody could claim that they've made a mistake when they realized that they didn't want to go ahead with the contract, back out, and everything would fall apart. So the court came up with the two-contract theory of tendering. They say that there is a process contract created as soon as a bidder submits a compliant bid to the owner. And that process contract binds the bidder to entering into the construction contract if the bid is accepted. There's no option to back out of it. And conversely, the owner has a duty as well. They have to treat the bidders fairly. So in this case, it seemed harsh. Ron Engineering had to lose its $150,000 for a math error. But the court explicitly said that the entire Canadian construction industry was more important than the well-being of one mistaken contractor. If they were to give that guy his money back, then every future bidder who got cold feet would just claim they made a math error to back out of their bid.
Well, there's two things here. Do you want to work with a person that clearly is not happy? They'll sign the contract for what they said, but they're going to spend the whole time trying to say that everything's going to become an extra. They're going to try to recover the money.
Yeah.
So do you want to have somebody like that doing your job? No. Can you negotiate? Can you say, okay, well, we're not going to give you your 150,000, but how's about 100,000 and just be done with it? You can negotiate that.
Mm-hmm.
You can do a lot of things in life.
Yeah.
You don't have to stick with the rule. You don't want to have a contractor that's so aggravated doing your work, because it's going to be a nightmare. And I was a civil servant for a while. I'll tell you something, a civil servant doesn't want any more work than they need to do.
Mhm.
And this smells like, just hardship all day long. So I would say to the guy, look, here's 100, just bugger off.
Well, you might be quite right about that. And I'm sure there are cases where that is exactly the right thing to do. We can't know all the particular facts in this case, but obviously the owner did feel that it was unfair for the other bidders to not press the strict rules in this particular case. I'm really showing this or describing this because it leads to a whole series of other considerations about tendering, which get very, very interesting. I can tell you I spent 10 or 15 years as a construction lawyer dealing with this exact scenario over and over and over again. And you can't believe how many permutations and combinations of issues come up. For example, how do you react as an owner if you want to avoid being sued by a contractor who says he should have gotten the job and didn't? You try to put in an exclusion clause. You put in the clause which says the lowest or any tender not necessarily accepted, or you
Exactly.
say, you say we won't be held liable for any alleged breach of this process contract. This gives rise to a whole series of other disputes about what clauses are enforceable and what not in contracts. And it doesn't apply just between the owner and the general contractor. It applies between the general contractor and his subcontractors, as I was saying a minute ago. And it's very important that for the integrity of the bidding system, that once this process contract crystallizes, the same thing happens at every other level in the chain. And the result of this decision, which is original to Canadian law, by the way, it's a Canadian invention. It has caused great certainty in the tendering system in Canada, and it's been very beneficial. So I'll leave the further discussion of the outflow from that case for another time, and we'll wrap it up with that.
Well, I can't wait for the next legal battles to come up.
Okay, see you next time.